Michael Cooper, and we are joined by Murray Rankin, who has seconded your bill, and that's what we're going to talk about. But can you tell us about your bill? What is it that you've identified that's actually an impediment for people to seek help when they're suffering from PTSD?
So my bill deals with the jury secrecy rule, and it amends the section of the criminal code, section 649, that pertains to the jury secrecy rule. One of the things that we heard at the Justice Committee when we undertook an all-parliamentary study, the first parliamentary study on juror supports, was that a lot of jurors who go for difficult trials and see the most gruesome of evidence and as a result suffer from PTSD are unable to get the mental health supports that they need because of the jury secrecy rule.
So they can't talk about it?
Well, right. So the jury secrecy rule, to be clear, prohibits a juror from talking about what happened in the course of deliberations for life.
Okay.
So that means that if you have PTSD or some other mental health challenge arising from your jury duty, you can't talk to a mental health professional about that. And a lot of the jurors said that the deliberation process is in fact the most stressful component, because after all, you're going through all of the gruesome evidence, you're deliberating on someone's fate about potentially sending someone behind bars for the rest of their life. So what my bill does is it amends Section 649 to provide a very narrow exception to that rule. What it would do is it would allow a juror to disclose what took place in the course of jury deliberations to a mental health professional in the course of seeking mental health treatment. That mental health professional, of course, is subject to confidentiality, and it would be post-trial.
Okay.
It's a small, narrow change, but I think it would have a real meaningful impact to support jurors.
Okay, and that's interesting. And you mentioned that this was an all-party committee that looked into support for jurors. Mary Rankin, you're supporting this. You're seconding the motion. So where does this go from here? Obviously, does it have cross-party support, do you think?
Well, it certainly has the support of the NDP and the Conservative parties. Now, we're hoping we can get the Liberals on side. It was a unanimous report, so one is optimistic. Some of their members have told us that they agree with this initiative, and hopefully we can get, I would like, unanimous consent to get it over to the Senate, where we've already talked to senators who are prepared to run with it as well. We need to move on this very quickly. There's some big trials coming up. The Bernardo case has brought to mind all of this anguish from the past, but we have the MacArthur trial in Toronto, we have the Toronto van, we have the Oland case in New Brunswick, any one of which could generate a lot of trauma for the jurors that are required by law to be on that jury.
So your focus then is to get all-party support. Is your focus maybe to get the government to take this on as a government bill, or were they just a unanimous motion?
I'm hoping we can move this bill through unanimously because the life of this Parliament is running out.
Yep.
And so we need to expedite it. I'm encouraged that today Ron McKinnon, who is a member of the Justice Committee, the Liberal MP for Coquitlam, Port Coquitlam, has indicated that he's willing to sponsor the bill.
Okay.
I've had other conversations with other Liberal MPs who have expressed support, so I'm optimistic that we can move this forward. We should move this forward.
When the Senate gets a hold of it, the Senate have a lot of legal minds up there. They're probably going to want to go over this in terms of, to describe this as Section 649 of the Criminal Code. Are there any complications, or is it as simple as that? Just make this one exception.
Well, I think it's a very straightforward bill, and I thought long and hard about any downsides to it, and I can't think of one. In terms of the purpose of the jury secrecy rule, this bill doesn't impact upon those things. I mean, some of those things include the need to protect the sanctity of the deliberation process or to ensure finality of a verdict. This doesn't impact upon either of those things because, again, we're talking about a narrow exception to talking to a mental health professional, totally confidential context in which that information is disclosed post-trial.
So both of you are going to go now and proselytize and try and twist some arms and try
Missionary
and
work in both the House of Commons and the Senate.
Right.
Let's get this through quickly. It's not controversial.
Okay, well, both of you, thank you very much for talking about it.
Great. Thanks so much.
Thank you.